Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on the docket today is Younkin versus Blackwelder. Counsel for the petitioners may now proceed.
Good morning, Kansas Gooden on behalf of the petitioners. I like to reserve 4 minutes for rebuttal. May it please the court. We ask this court to treat civil plaintiffs and defendants equally in their discovery obligations and opportunities. This will foster a balanced search for the truth and ensure a fair trial for both parties. Several years ago, this court issued the decision of Worley versus YMCA. The court considered whether the referral relationship between a plaintiff's law firm and the plaintiff's treating physician was discoverable. The majority opinion found that Allstate v. Bosher did not apply and distinguished it on the grounds that the law firm was not a party to the lawsuit. The majority opinion further found that the referral relationship was protected by attorney-client privilege. This ruling has created unequal treatment between the parties. The jury does not hear about the referral relationship on the plaintiff's side of the case. This gives the jury the false impression that the plaintiff's witnesses have no financial interest or relationship in the lawsuit.
Counsel, I'm sorry to interrupt you. Could you address the sort of procedural / jurisdictional issue in terms of, so this was a decision on certiorari, and the question for the district court was whether there was a departure from the essential requirements of law, right? Correct. And so what exactly are we being asked to decide? I mean, are you, in terms of applying the existing law, is there any question that what the trial court did here departed from the requirements of the essential requirements of law in terms of, you know, that pretty high standard?
Well, I think there is a question because precedent has to be read even-handedly. And so if this precedent is read solely to apply to the plaintiff's side of the case, that creates issues in fundamental fairness and equal protection in the law.
So what's the requirement of law? What is the essential requirement of law that was departed from, in your view?
The majority opinion distinguished Bosher and found that Allstate v. Bosher did not apply to non-parties to the lawsuit. And that is the essential requirements that we relied on below. And that's the decision from this court that established that. And that was the first case in Florida to decide that on that basis. Before Worley, non-parties were subject to Bosher discovery on both sides. And that went all the way back to Springer v. West.
But the trial court's decision here was consistent with Bosher, right?
It was consistent with Bosher.
Okay.
It was.
And so hold on. So it's consistent with that. And so what is it inconsistent with?
The fact that Bosher only applies to non-parties or parties to the lawsuit. And that's where kind of the rub is in this case. And that's where the unequal treatment in the law has been created by the Worley decision.
Okay, I'm sorry, go ahead.
No worries. So basically what the Worley decision did, it creates a false impression where the jury is only hearing the defense's impeachment. This is troubling because these personal injury cases are battle of the expert cases. And it really falls down to the credibility of these experts. Who does the jury believe? And so impeachment of these dueling doctors can have a significant effect on these trials. And it ultimately thwarts the truth-seeking function, and the jury is not given the whole story on both sides of the case. Now, I anticipate my opposing counsel will focus on, the plaintiff side has treating physicians, the defense side has compulsory medical examiners who are listed as retained experts. However, that should not be the distinction. Both of these types of doctors are giving expert opinions. They're opining on causation, permanency, future medical care, and they're often handpicked by both sides. And in this case specifically, the plaintiff did disclose the treating physician as experts. And just focusing on the fairness, a defendant doesn't have treating physicians on their side of the case. They can only defend the case by using a compulsory medical examiner. And the entire purpose of that compulsory medical examiner as set forth in Geico versus Berner is to level the playing field. And so if the focus is on treating physician versus an retained expert, the defendant always starts out behind the 8 ball.
Can you though, so,
Go
go ahead.
No, go ahead.
No, go ahead.
Okay.
If the problem though is that Worley is wrong, how do we get from the, how is this case the proper vehicle to fix that?
Well, we have from day one asked to be treated equally.
We should sort of take a bad decision and just make it kind of doubly bad by applying it in this context?
Well, I think this court has discretion to structure its decision how it can to make the parties equal. And I think ultimately that is what the court's goal should be, taking the intent that this court really focused on in Elkins. It talked about how Elkins was discoveries not intended to focus on one party or the other.
Okay, but assuming that we accept that the discovery rules apply to all parties equally, what is the discovery rule we're talking about? What's the actual rule number?
So this line of case law has developed through the common law. There is one rule 1.280 that deals with the discovery from the expert, essentially serving interrogatories on the party to get that information from the expert. If the parties stuck to 1.280, we wouldn't be here, because 1.280 does not say you get all the payments from these non-parties. You don't have to disclose every court reporter name and address of every deposition this doctor ever set for.
Right, but your proposition is that the rules should apply equally, and I'm asking what rules should apply in order to get to the point of what is the rule. In other words, you've taken the position that nobody should get to the discovery because we should follow Worley. I'm asking you, what does the rule say, and what discovery is available under the rule? In other words, is there information that your expert should have had to disclose under the rule?
Correct. Under rule point 1280, the scope of employment and compensation for the pending case, the expert's general litigation experience, basically the percentage for plaintiff versus percentage to defendant, the identity of other cases for trial and depot testimony, and that's referred to the Elkins list, and the approximate of experts' involvement as an expert. So number of hours or the percentage of hours.
But you're taking the position that under Worley, your expert should not have been required to answer those questions.
That's not the case. So I think both parties should be answering rule 1.280. It's the questions that are above and beyond 1.280 getting to the impeachment. And that's what is at issue in this. It's the how much money is being paid, and how many times have you been retained? And that's way beyond the Elkins list. And that referral relationship is protected on the plaintiff's side of the case. Under the Worley decision, the defense cannot obtain information about that after Worley.
Well, I understand. Let's put Worley aside for a moment. I just have a great deal of difficulty understanding how that information is not highly relevant to the issue of bias. I mean, which is, we talk about these rules of procedure, but there's a substantive right to evidence related, relevant evidence related to bias, isn't there?
Pre-Worley, I would absolutely agree with you. I think this information is highly relevant because it does go to impeachment. However, post-Worley, Worley turned this area of law on its head. And I think because of Worley and how it was written, it changed the landscape. And because of now this entire area of law on the plaintiff side is protected, it has to be read equally between plaintiffs and defendants.
I'm going back to the jurisdictional question. So in order for the Fifth District to answer the question, they had to determine what the law was and therefore what the essential requirements of the law are. So, and that's actually what we're debating. So what, assuming that we decide that that the rules apply equally to every party, which I think is a pretty basic proposition, then you have to ask, well, what is the rule in this context? What discovery is permissible? And only then can you determine whether there's a departure from the essential requirements of the law once you determine what the law is, correct?
Correct.
Okay. And there is a position, what position, is there a limitation in the constitutional provision under which you appealed? In other words, a question of great public importance that would limit our ability to hear this case, I think is where Justice Muniz was going.
Yeah, I don't think there's any limitation. This court has accepted jurisdiction on a certified question of great public importance. And because of that, it is a legal issue for this court and it can review it de novo. It is not confined to that certiorari review. And
you don't think that the district court needed to disagree with the lower court as to what the law was in order to certify a question related to the law that's at issue in the cert petition?
No, and it couldn't have. Essentially, the way Worley was written, they basically said because it's referring to on the plaintiff's side of the case, they said it didn't apply to the defense, and it applied the Bosher case, and so that's kind of how we ended here. They found that this argument that the parties were not being treated fairly compelling, and that is what prompted the certified question of great importance.
I guess though, but this is just it's an odd posture because it doesn't seem like really it would make any sense for us to extend a deeply flawed precedent to another area. On the other hand, using this case to, I guess, overturn a precedent that doesn't really apply to these parties, I mean, that seems strange too. I mean, do you have any thoughts on that?
Well, I think this court has options with how to go about doing this. And, and I think the next case will also be dealing with these same options. But essentially, how do we fix this? Because I think this court should strive to make discovery obligations and opportunities equal on both sides and strive for essentially a balanced search for the truth. I think there's essentially three avenues. Number one is kind of overturn Worley and allowing everybody to obtain the information, going back to where this was in 2017 before Worley was issued. It could hold the reasoning of Worley applies to all non-parties, and this would essentially make Bosher limited to cases dealing with the parties' impeachment. And then the third rule is what the doctors actually argued in their amicus brief is limit all bias impeachment to Rule 1.280 for everyone. And this is kind of goes back to what Judge Nesbitt wrote in Elkins in the Third DCA opinion years ago about this impeachment can be done through a very simple cross. And it doesn't need to be very extensive. You can get across that somebody's being paid and by a certain party and has that bias without spending a lot of time. And this bias really is taking up a lot of time. I mean, in our record, we have the deposition of this doctor. The majority of the time is spent on impeachment.
Let me just ask you, so would what you're talking about require a rule change in order to determine what was actually discoverable, to narrow it and define?
I don't think that Rule 1.280 needs to be amended at all, because this line of cases developed through the common law. It did not develop through the rule.
I mean, isn't due process better served if the rules that we all play by and the court system are laid out very clearly in the text of the rules, rather than having to figure out what the law might be as it evolves from courtroom to courtroom?
Well, Rule 1.280, I mean, just going back to Bosher said that rule didn't even apply in that situation. And so that's how this whole line of cases got outside of the rule. And so that's why the rule doesn't even come into play in this analysis, in this line of case
Right,
law.
but in our rulemaking role, couldn't we come up with a rule that says, with this type of discovery, this is how you get it, and this is what you're entitled to? And then figure out what makes sense and what balances best the need for the cross-examination information, the financial bias information, along with, in the search for truth, along with the cost of the litigation, and making it accessible, the court system accessible. I mean, that's the sort of policy balance that you can handle well in a rulemaking situation. I don't know if it's the kind of thing that's appropriate for a case. That's my question.
Well, I see I'm into my rebuttal time. I'd like to reserve the remainder.
You don't want to answer the justice's question?
Oh, sorry. Sorry about that. I think that the rule is sufficient the way it is and does not need to be amended. If it does amended, the rule actually allows this court to do it sua sponte without having to go through the entire rules committee process. This court has taken that avenue on several occasions, because if we go through the rules process, this problem is going to continue and keep continuing until that is solved. And that is going to keep compounding through the number of trials that will be coming down the pipeline, especially once jury trials start.
How does the rule process, though, overlay with the I mean, Chief Justice Kennedy mentioned, I mean, we do have a substantive entitlement here. I mean, how much can we sort of pare that back through the rules?
And kind of going back to the rule, this whole line of cases developed outside of the rule. So it would take a significant amendment to pull this entire line of cases back. Whereas doing it in a opinion from this court is a simple way to pull it back. It is essentially, going over a speed bump versus climbing a mountain.
Okay, I'm sorry, you're way into your rebuttal, and it's partly my fault, so I apologize.
Well,
No
counsel, I will atone for all of us by giving you 2 additional minutes. So you'll end up having 4 minutes for your rebuttal.
Thank you.
I may need more atonement than that in this case.
Well, I have my limitations. All right.
Good morning, everybody. So I was going to start with where the questioning started, but let me follow up right quick on this rule making issue. That's probably, given the posture of this case, if the court was inclined to deal with the issue, the perceived issue from Worley, then the rulemaking authority would be a proper way to do that, or a real case in controversy dealing with that actual issue. And I would just remind us all, in going through the rulemaking, how important it is to get public comment, just thinking about the civil cover sheet and what we all just went through with the civil cover sheet on something that seemed as innocuous as that. And so it's a good way to deal with it, and it allows all sides to air the potential issues. And I will get in a moment. Yes, sir.
Mr. Nation, so that I agree with that position that once you figure out what the rule is, if you think it's a bad rule, then you go to the rulemaking process to fix it. And then, so there's that issue. What should the rule be? That's rulemaking. We shouldn't decide that in this case. There's what is the rule, which is at issue in this case. And then there's, does the rule apply equally to all parties in litigation? And that's the big issue that is definitely at issue in this case. Because the Fifth District, if we leave this case alone, then it's a precedent that says that the rules of civil procedure and discovery do not apply equally to both parties in the state of Florida. Is that a proper rule?
Let's talk about the posture. I'm going to answer that. I'm going to talk about the posture and get where I was going to start. And that is, why are we here? There was a petition for cert filed from the trial court. The trial court, the law which the trial court followed is settled, clear, and unambiguous. It's Vasquez versus Martinez, Herrera versus Mustafa, Springer v. West, and even Worley all make clear that the discovery about the financial connection between a law firm and its specially retained expert for trial is relevant and it is not privileged. And therefore, in the Fifth DCA held, the trial court did not depart from the essential requirements of the law, but indeed followed the essential requirements of the law. We shouldn't have a loosening of the certiorari standards here.
Right, but
justices on this court have written that. Yeah.
In the real world, doesn't that leave us in a legal posture where the governing principle is that the rules of civil procedure and discovery do not apply equally to both parties in the state of Florida? And that's
okay. They are applying equally. They apply equally to retained experts for sure. Everybody can agree on that. But then looking at the issue, I certainly.
But okay, let me stop you there, because what's discoverable is related to what can come into evidence.
Correct.
And what can come into evidence does not make a distinction of whether a witness is a retained expert or whether the witness is something else. The only distinction that it makes is whether opinion evidence is allowed to be offered through the testimony of this witness. In other words, whether this witness is an expert. So based on our rules, expert witnesses are expert witnesses. So the question is, what are the rules that apply to expert witnesses? And if one side gets different rules because their expert is retained, there's no rule-based or law-based. Well, there is a law-based, because Worley says that's the law. But I would say that is treating parties differently based on a distinction that's not in the law. And that is at issue in this case. So is it appropriate to apply the rules differently based on a distinction that's not drawn in the law? In other words, whether someone who's allowed to offer opinion testimony is retained or not.
So I understand, and I certainly get the appearance that it is unfair and applied differently. Let's scratch the surface, because on the surface, I agree. But let's scratch the surface and look at what's really going on. With a treating doctor, the only way you can bring in evidence from other cases, and that would be bias, would be if there was a payment from the plaintiff's lawyers.
Okay, so is treating doctor a distinction that's drawn in the rules of discovery?
It's not mentioned there, no.
Okay, so what we're dealing with is this person, whoever it is, in their role as a witness who's going to offer opinion testimony, and the rules call that an expert. So that's the only distinction that's drawn. So tell me how I can draw a distinction and say that you can get financial bias testimony from one party's expert, but not from another party's expert. So
that's exactly what I was heading into that, and I'm glad we're there. You got to scratch it. Once you get past the surface analysis, the question then becomes, is the law firm paying the treating doctor, the witness? So there are two ways to show bias. Is the law firm paying the treating doctor? The answer is no, and I'll explain that in a second. The second issue is—
So I understand that, but say that the law firm refers the patient that allows, so there's a business relationship that put $1 million into the pocket of that potential expert, and the money was only there because the lawyer that is examining the expert when he's on the stand directed that financial gain to the expert. Would that be a basis for bias?
If it can be, absolutely, if it can be shown, because sometimes it is shown on the intake forms who referred you, that's fair game for sure. Now, in this case, there is no record evidence whatsoever of a referral. That's not this case. All the more reason to have a true
Well,
case.
is there a referral relationship between the attorneys at issue in the case and the expert witness?
Let's talk about that.
Wait, I mean, but isn't that a relevant question? If you're going to be able to bring out the truth at trial, if you're going to be able to cross-examine a witness as to bias, is there a referral relationship?
So the question then becomes, how did that client get to the doctor? Many of the clients come in and they're already treating with particular doctors. They're already, and there's no referral. What the insurance companies want to do is throw in a number. There are 200 common clients. That doesn't mean there was a referral at all. And so we can't just, we would never just throw in that evidence, 200 common clients. You would have to look at the evidence. Is there independent evidence of referral?
Okay, but the question is potential bias. And is the bias any different if the doctor referred to the attorney or the attorney referred to the doctor, as long as that relationship with the attorney that's standing before the jury questioning the expert who's giving testimony they have this symbiotic relationship in which one sends business to one and one sends business to the other, and the position is that that's not discoverable because it's not going to lead to the possibility of evidence of that financial relationship?
If there is an independent source that the doctor referred to the lawyer, that can be brought out in cross for sure. Same as if there's an independent evidence that the lawyer referred the patient. But
so is it your position? I mean, what you're saying is though that the referral relationship is evident. The financial is evidence of financial bias, which means it would be discoverable between that expert and the attorneys, correct?
But here,
if the rules applied equally.
If that evidence is there, if it's in the intake form, fair game. I referred to the patient and it's in the intake form, it's there. But what I want to get to is what the insurance company is really wanting to do and how this has to be dealt with. And that is, if let's say there's 200 common clients, what the insurance company wants to do is throw that number 200 in front of the jury. When in reality, there's no evidence. Many of the people may have come, let's say 50% of them went to the doctor or the lawyer on their own with no referral whatsoever. So the question is evidentiary. How do you get the evidence? And I do want to address the attorney-client privilege because now we've been laboring under, or not labor, we've had Worley for 3 years. The conversations that have occurred between lawyers and their clients for the past 3 years, the Supreme Court of Florida said those are confidential. Those can't be opened up now at this point.
Is it your position, though, that those conversations are for the purpose of preparing for litigation?
No, well, it is the purpose of attorney-client relations because our clients have a duty to mitigate their damages. And so an injured person comes into a plaintiff's lawyer's office, we have to explain to that client, you have a duty to mitigate. The client naturally, as a part of that conversation, would say, how do I do that? And often it would come up that
I just want to be clear. Your position then is that when someone seeks treatment for a head injury, what they're doing is mitigating damages as opposed to getting treatment for a head injury.
Oh no, it's mitigating damages by getting better, for sure. Absolutely, it's getting better. They have a duty to try to get better.
Where does that duty come from?
The duty to mitigate damages. In our personal injury cases, almost every case, the insurance company said if there was no treatment, hey, they didn't go get treatment.
So
they had a duty to mitigate.
you're saying that, so I just want to make sure I understand the sort of scope of your position. You're saying that if I get hit in the head in a car accident, I have a duty to heal that I do not have if I hit myself in the head.
If you're seeking a recovery from somebody else, you've got a duty to mitigate your damages. I mean, and you would have to do what you could to get better if you're going to ask somebody else to compensate for. And if you don't, the jury's going to take that into consideration. As part of that protected and privileged conversation, it certainly could come up. It might come up. How do I do that? My doctor won't take accident victims. That is protected by the attorney-client privilege. You can't.
So is it your position that just a simple referral by the lawyer to a medical treating physician for treatment is an attorney-client privilege communication?
Justice Polston, I read your dissent 5 times in the past 2 days in Worley. So yes, and it is, but because I don't think this argument was made to you, this duty to mitigate, and then if just the fact of the referral comes out that occurred during that attorney-client communication, if the fact of that referral comes out, then we're required, because that might look bad, we have to open up the entire conversation and then put in front of the jury, well, listen, our clients have a duty to mitigate, which is clearly a protected conversation, a duty to mitigate their damages. This is part of the advice that we give, is to mitigate, to get well. You have a duty to try to get well.
I question whether a simple referral for medical treatment, that by itself constitutes an attorney-client privilege communication. But having said that, that's probably a case for another day. But it does seem to me, as Justice Lawson indicates, there needs to be an even playing field. I thought that in my dissent in Worley. I still think it today.
So all the more reason, a actual case in controversy or rulemaking, where all these positions can be brought before you.
Well, it seems to me the certified question from the DCA is squarely before us. I don't understand why we don't have jurisdiction to address the certified question according to the Florida Constitution, and why we should not do so.
Well, I'll give you 2 cases, and one of them you've concurred with is Rodriguez versus Miami-Dade. And the issue there was the emergency exception. And you said, or Justice Kennedy said, the issue is whether the 3rd District could properly conclude that the circuit court departed from the essential requirements of the law. The trial court did not depart from the essential requirements.
Respectfully, that's not the certified question before us.
I understand, but that certified question was never passed upon. They said it in the opinion. At the end, they said, here's what the law is. We're following law, and this wasn't passed on, but it is an interesting argument that's been raised.
But the question is, what text in the Constitution limits our ability to pass on that question now that it's been certified?
It wasn't passed upon by the Fifth DCA.
Okay, and I'm
Article
not looking
5,
at the
Section
Constitution. I
B4.
can grab it, but is that part of the text of the Constitution? Is that a limitation in the Constitution, or does it just require a certified question?
It's Article 5, Section B4. It's got to be passed upon. And it wasn't. They said it in the opinion that it wasn't passed upon. And so, for that, and I obviously you're looking this up. If you've got questions, I'm happy to chat about that. I would, again, point out, once you scratch the surface, which is why I think the rulemaking authority would be so important in this case, or an actual case in controversy, to get past the surface and talk about what is admissible evidence in a case, in a particular case. Certainly not in this case, because there is no evidence of any referral in this case. And then what is admissible and what is not misleading. We cannot mislead the jury. We can't simply put in, they have 200 common clients and then expect the other side to come in and clean up the misleading evidence. That's not what our rules of evidence are for bias. We would never be able to just simply put in a number without some foundation.
Isn't that, you just said that should be rulemaking, but now you're talking about what the rule should be. And I tend to agree with you, that's rulemaking. But the primary question is, whatever the rule is, should they apply evenly? And that's the question that's certified. So assuming that we have jurisdiction to answer a certified question, we can answer that question. And then we get to decide within our discretion, I believe, whether we get to the next question is what the law whether the Worley makes sense or not, and then is there a better rule later for rulemaking? So assuming that we do decide to answer the question, should the rules of civil procedure and discovery apply evenly, you would agree that they should apply evenly, assuming that we decide to answer the question, correct?
With
To all expert witnesses.
with this caveat, there are many rules that apply and they're just not even. For example, an insurance company or defendant can file a proposal for settlement for $1, and they don't have to pick a real number to try to get a case settled. There's no incentive for them to do that. We, on the plaintiff side, have to pick an actual number that we think we can get in order to trigger a PFS. That's unequal. Who got the ticket? Unequal. So there are these judgment calls. And I think after hearing everything, that judgment would be made. On its face, everything.
So I think I understand your argument for why we shouldn't answer the question at all. I understand you to be saying that we should answer the question, and we should say that that the rules of discovery, civil procedure and discovery, should apply differently to different experts. I'm having a hard time understanding what the rationale would be for that in holding.
On its surface, easy to say they should be equal. However, it has to be evidence and fact based. It can't simply be how many common clients do you have. There has to be some evidentiary basis.
Okay, but that gets further down to what the rule is or should be, what the rule should be. I'm just saying,
generally,
why should the rules apply differently?
Well,
different experts.
I mean, obviously, they're applying the same when we talk about retained experts. Then the question becomes, with a treater, we have an evidentiary issue that has to be addressed. But again, that's not even the question that was asked. The question was asked.
Counsel, so
Yes.
it says here, the question is whether the analysis and decision in Worley should also apply to precluded defense law firm ... If the answer to that question is no, because Worley was wrongly decided, would that be an inappropriate, just procedurally? I'm not saying that substantively you would say that that's the right or wrong answer, but in terms of squaring this with our jurisdiction and the question and everything, would that be an available path to the court?
I think the better path is no, the analysis and rationale don't apply because there's no attorney-client privilege.
Right, okay, so that's one path.
Yeah.
But if we're just talking about the appropriateness of us getting to the issue, what's wrong with the path that says, no, it should not apply because Worley was wrong?
Because Worley needs to be argued, the facts, those facts in a real case or controversy, dealing with many of the issues I've raised today that I don't know were raised in Worley. Those need to be dealt with. So I think it would be inappropriate to simply go outside the record in this case, go outside the decision in this case, which was that the trial court did not make a mistake at all, a legal error at all, and then take the next leap and say, because Worley was wrongly decided. It is a true case or controversy issue. I think it would be fundamentally unfair and wrong to rule that Worley was wrong in the circumstances of this case. You don't have the record that's been made in front of you, and that's not the issue that either side has raised in this case. So,
Counsel, let me ask you this.
yes, sir.
We can rule in your favor on grounds other than the district court ruled in your favor, right? And just as a general principle of the appellate process.
Well, this isn't, obviously, this isn't an appeal. Obviously, it's cert, and so I don't know how you get there because there's.
And you're the respondent here, and we can rule in favor of the respondent on a ground other than the ground that was the basis for the district court's decision. Isn't that correct? That's old tipsy coachman.
I don't think you can in this case.
Well, but isn't that a general principle? Isn't that a general principle of our structure of the appellate process?
Well, I don't know. Yes, it is a general principle, no question.
Okay, that was my question. I understand you don't think we ought to do it here. I appreciate that, and you might be right, but that is a general principle floating around out there.
It is a general principle, but I don't know that in this case, just because there's no material injury, we haven't even gotten to that, no material injury. This is the same information that's been given up by retained experts for 20 years. And so I don't know that the Fifth DCA even had jurisdiction on that ground. And the discovery, if it was an error, could be dealt with on a plenary appeal. Yeah. That was the basis of my answer for that. But I appreciate all the questions, everyone. Thank you very much. That's all I have.
Okay, we thank you. Now we'll go to rebuttal.
Very quickly, my opposing counsel mentioned two cases, Rodriguez, and I believe the other one he was referring to is San Paradillo. Both of these cases arose in a different context. The certified question actually had to do with whether a writ of certiorari was the appropriate vehicle to review a certain action. They were both immunity cases. So it's completely different, and it does not limit this court's ability to review a certified question. With regards to the argument about the Fifth DCA did not pass upon the question, we disagree with this because in the opinion, they set forth their argument and they squarely rejected it. And they said that basically Worley was not written that far and the order is more consistent with, Worley Bosher and the cases that came after Bosher. So they considered our argument, they rejected it, and that's what passed upon means. They decided the issue.
But counsel, isn't it, this is a weird situation because, on the one hand, it seems like the Constitution gives us a fair amount of latitude to answer these questions, but this is a kind of an oddly worded question. Shouldn't district courts be phrasing their question in terms of does such and such case apply? Asking us to say whether the analysis should apply. That's almost just like sort of teeing up for the court, this kind of abstract, almost advisory sort of question. I understand that it's not advisory in the sense that if we say no, because X, Y, and Z, it could lead to a certain outcome in this case, or yes, because X, Y, or Z. But is this really a properly phrased question?
So this court has answered similar questions in the past that were framed in a similar manner, but this court always has within its power to rephrase this question to its liking. And it has done this numerous times over the last 40 years since 1980 when this certified question.
So if we rephrased it in terms of does the analysis and decision in Worley apply to preclude a defense law firm, blah, 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 the answer to that would clearly be no, right?
Again, I would disagree. It really depends on what the court plans on doing with Worley in this case.
No, but just take Worley as it is. Does the analysis and decision in Worley apply to preclude a defense law firm that is not, et cetera, et cetera? The answer to that would be no, right?
I would argue that the answer would still be yes. And this would be based on the express wording of Worley that says Allstate v. Bosher does not apply because the law firm is not a party to the lawsuit. Again, that majority opinion did not have to be worded in that manner. And because it was, it needs to be applied evenly on both sides. But ultimately, I think this court's decision, it really boils down to what to do with Worley, because Worley it's the elephant in the room. And I think all of us kind of have to admit that. It really upended the law in this area and changed everything. And so today we ask this court to kind of turn its focus back to what we did in Elkins, and emphasize that the discovery is intended to favor neither plaintiffs or defendants and that both parties have to be treated equally. Thank you.
All right, we thank you both for your arguments in this case today. The court will now stand in recess for about 15 minutes.